Okay, ready? Start. Yes, it's on. We are
Okay,
live.
this is collaboration session 3, and we are group 3. Our topic that we have chosen is no pass, no play, and also the exclusion from extracurricular activities. I'm going to start talking with the House Bill 72 and kind of just a general overview of that law. The no pass, no play was enacted by this Texas House legislature in the House Bill 72 in 1984. This rule states that students who participate in extracurricular activities in the public school setting must obtain a passing score of 70% or higher. Now, these are just regular ed classes for the 70% or higher. If a kid is taking a pre AP class or an AAP class or even a dual credit class, they can make a 60% or better. They get an additional 10 points. And this was big for me this soccer season because I checked report cards and I thought some of my best players were failing and not going to get to play. But little did I know that these were pre-AP and AP classes. And now this is only on the 6 weeks report card. This rule does not apply to students who are failing at the 3-week report card. Students are still eligible to participate and practice during the suspension time. So just because they failed the report card and they don't get to play in the game, that doesn't mean they get out of the wind sprints. A student can regain eligibility if they are passing all courses at the 3-week progress report. And I would like to put an emphasis on all classes. One misconception is that a lot of extracurricular students think that just because they failed math and now they're passing math at 3 weeks that they gain eligibility, when in fact, if they failed, say, math at 6 weeks, they have to be passing all their courses at 3 weeks to gain eligibility. And a question that I had was, what exactly is considered a extracurricular activity? And UIL defines extracurricular activities as if the activity is competitive, if the general public is invited, if an admission price is charged, if the activity is held off campus, if the activity is held in conjunction with another activity that is considered extracurricular. Some examples would be athletics, band, orchestra, choir, debate, drama, speech, writing, literature, mathematics, sciences, technology, foreign language, ROTC, and even cheerleading and the drill team. This plays a huge role in Texas because for me, athletics is a huge deal and it's a huge part of our school, and so is cheerleading, so is all extracurricular activities. So when a kid gets out, it fails a class and has to miss these 3 weeks, it can have detrimental effects on a school. And I think that's why this is such a big deal and very controversial, and why there's been several lawsuits and court cases over this. Anybody like to chime in?
Um,
Oh,
I wasn't aware of all the examples of extracurricular activities, and mainly because I went to a small school. We didn't have ROTC, forensics for sure. I don't even know what that is. I mean, I know what forensics is, but I'm thinking, as far as it's school related, what does that deal with? Do you know what that deals with, or that was just on the list, or?
I assume it's like playing CSI and trying to uncover a case using scientific methods.
Oh, okay, that's interesting.
Yeah, our school didn't have that either.
um, okay. The second part, I guess I'll start. Some discussion points that I actually looked up was that Texas is actually the only state that has enacted a no pass, no play statute. Okay. Um, The law specifies that a student who does not maintain a 70% in all courses except certain honors or advanced classes, as Chaden had mentioned before, must be suspended from extracurricular activities sponsored by the district or UIL for at least 3 school weeks or until the grade is raised to a 70% or higher. Texas Education Code Section 21.920 states that, and where do I have it here? Let me change spots here. Disability and no pass, no play interferes with making academic requirements must be based on a student's failure to meet the terms of an individualized education plan, and so if IEPs are not followed, then this is the only way in which a person that has a disability is not able to participate. No UIL competition are to be held Monday through Thursday or the last testing day during the week of statewide assessment, and this is from Texas Education Code 33.0812. And also, UIL must submit rules and procedures to Commission of Education for approval or modification, and this is by way of Texas Education Code 33.083. Back to the disability aspects, I did research on 504. Here it is. Okay, this is actually a little tricky, especially when it comes to disability, because perhaps not intentionally, the Athletic Association regulations sometimes exclude students that have a disability from participation, but published court cases primarily focus on Athletic Association and the analysis that provide practical lessons for school districts both on the playing field and also in the classroom. So because a person is Section 504, according to Section 504, the idea, qualified individuals with a disability shall solely, by reason of his or her disability, be excluded from participation, be denied the benefits, or subjected to discrimination under any program or activity receiving federal financial assistance. It's actually a lot of case laws as well concerning this as well. Some other court cases: Niles versus University or UIL, 1983. Fifth Circuit ruled that UIL has 1-year residency requirements for eligibility to participate. So if a student comes from another district, they can't just go from district to district and be allowed to play. They actually have to sit out for that particular year before they can actually participate. I also thought it was very interesting that certain states, their no pass, no play differs than others. And in Montana, student must maintain a 2.0 or C average to participate in extracurricular activities. In California, they must have a C average and also have no failing grades to participate. And then in Connecticut, it says a student must maintain a 1.5 or a D+ to participate in extracurricular activities. So I thought that was kind of bizarre. And a couple of other court cases that I did look up, which I thought was interesting. Oh wow, let me find it. I got too many papers here. Anyone else, feel free to come on in if you want to. Oh, here it is. There was no pass, no play. This occurred in Mississippi. This was court case EC X Rel Chapman versus Mississippi High School Athletics Association. Now, originally, the background of this is that an African American high school student brought action against school district, high school, athletic directors, saying that he was discriminated against because he was forced not to participate in football program following his transfer to a different high school in the same districts. Originally, he tried to say that it was discrimination based on his color, but he transferred from a different district, and so he wasn't able to play, football in that particular year. So it was actually dismissed. And then the last case that I have is Indiana High School Athletic Association versus Schaefer. Now this was actually a bizarre case because this particular student played like the first 2 semesters, and he came down with this bad bacterial sinus infection. So, and this was during 90 and 91 school year. He was a junior at this high school. He played on the basketball team the school year, and he actually went to the he played fall 90 and spring of 91 semesters of the basketball season. And so during the last half of the fall semester and the first half of the spring, he was a member of this particular association. But he had to withdraw from school in spring of 91 because of this sinus infection, and he tried to come back and wanted them to count that particular year because he had this bad sinus infection. He went to the doctor. The doctor gave him a notice, and what ended up happening is that he was not able to count that particular year because he wasn't in school the majority of the time that he had to be, so he did not get an exemption granted. So I thought this was kind of like a bizarre case. In order for him to be able to get credit, he had to be had received passing grades for the end of that grading period, but he didn't receive any at all because he wasn't in school the whole time, so they couldn't give him credit. And so that is all I have. And we'll move on to Blue versus UIL with Chelsea.
Nope.
I think Lori is up.
Yeah.
Yeah, thank you. I was going to start off with, I just have the no pass, no play. The basic message of it is academics comes first and failure has consequences. Texas was the first state to enact no pass, no play into law. And then some pros are it's intended to motivate students to pass every class, motivate them to stay in school. The teacher, most of it motivates them to stay in school. It teaches students the importance of academics. The cons, if you have no guidance on how to implement the policy, the results can be disastrous. Educators do not like reform demands from a sponsor or a coach to bring up the students' grades. Teachers may raise grades in danger of violating the no pass, no play rule. The policy has been revised twice, but needs guidelines on how districts are going to involve others in the implementation progress. There's also no reliable evidence of its positive impact on individual students. Then I have the Blue versus University Interscholastic League in 1980. This involved the 19-year-old, it's the eligibility rule. The 19-year-old rule provides that any student who reaches his or her 19th birthday on or before the first day of September preceding a league contest is ineligible to participate. After this case, Texas Supreme Court had advised courts to avoid interfering in the UIL's eligibility and forfeiture decisions involving high school athletics, emphasizing students' participation is considered a privilege and not a right. And then one case that supports this is Eanes ISD versus Logue. The court said intervention in matters such as these, they do more harm than good. Then I have in the RE University Interscholastic League 2000. In the spring of 2000, UIL required Robtown ISD to forfeit all games the baseball team played with an ineligible player causing the district to lose its place in the state tournament. A trial court ordered the UIL to permit Robstown to enter playoffs and held the UIL in contempt for refusing. And that's what I have.
Lori, when we were talking about the pros and cons, I noticed the first year that this went into effect, it said the Houston Independent School District failing report card grades for all high school campuses decreased from 16% to 13%. I was wondering if it was still that way or what the results are at this time.
Yeah, I didn't see. I looked up different statistics, but it just basically said that none of them were valid because there hasn't been. They haven't done like an appropriate way to conduct any kind of to get any kind of valid information to support that it is like helping students.
I don't think anyone would argue that an incentive to pass your classes to play a sport or an extracurricular activity is going to give someone the motivation to pass their class. I mean, that's kind of common sense, and I think everyone sees that without statistics, that it drives kids who would not pass, but now it's giving them something to fight for.
I would completely agree. All right. Well, I'm going to talk about a little bit of UIL stuff as well. UIL is used for many other organizations, like we've said. I am an FFA advisor, and so we have adopted UIL rules under our Texas FFA Constitution in order to kind of keep with you can't participate in any livestock shows, which livestock associations have also adopted the no pass, no play as well. So it's like it's in the Texas Education Code. It's also been adopted by several other organizations that bring in kids in order to get them all to pass. It is an issue with our kids passing their classes before the stock show, because I will leave your little butt at home if you don't pass your classes. I do want to point out that the UIL sports is sports excluding cheerleading, which is now part of Spirit, which happened in 2015. So kind of interesting that UIL has been around for years and years and years, but cheerleading didn't make it in until 2015, which if you are a secondary person or honestly just a random anybody person, you know that cheerleading is a huge deal with lots of drama that comes along with it, including lots and lots of law cases. So I just did want to point that one out. I did read on the UIL website that the school is responsible for making the rules and enforcing them. So while we have UIL as our backbone, which really is really great for schools to help have some kind of governing law on extracurricular activities and sports and stuff like that, it is truly up to the school district of how they want to use that. I kind of looked up some other cases. I kind of was interested in the athletic purpose rule. This happened to me when I was in high school. I changed high schools in between my freshman and sophomore year, and even though I was able to make varsity cheerleading, I was not able to cheer as a sophomore on varsity, which was pretty detrimental to me. But they said it was because I moved for athletic purposes, because the school was known for their cheerleading program. I did not move for athletic purposes, but I couldn't play. So in the Hatton versus UIL, it's a case where a student switched schools and could not play due to the athletic purpose rule. In this case, they said that it was between Early and San Saba, and they basically said the Early school district was making this happen because they were mad that this kid left and went to San Saba, whatever. But it does happen. Like, the other case was Niles versus UIL. Same thing. It's been happening since 1983, and I don't foresee it stopping anytime soon because there will always be that issue of students moving because of personal reasons, but also, because of athletic reasons too. We had the same. I went to Lake Travis High School, which at that time was in the middle of their state championship, years. So, we had kids all the time try to come and play football for us, which awesome, bring on the talent, but they did have to sit out a year and be on the JV team, and then they can be on varsity. But I remember this being a huge issue in our schools because that was the same time Katrina happened, Hurricane Katrina, and we got a lot of kids from Louisiana who moved to Lake Travis. Now, people have their thoughts on, did they move for football reasons or did they move just to relocate? But I do remember two boys being on JV when they went on to play college football, but they were on JV. I want to say their sophomore year, junior year too, because of the athletic purpose rule. Does anybody have anything to?
Chelsea, do you remember reading in this Texas law book that we have that talked about that case of the cheerleader who I can't remember what she was suspended for, and the next year she just regained her position, and there was a lot of people arguing, and they took it to court. And I don't know if you remember that the state court said that they don't have time, or that to hear frivolous cases on cheerleading, so they kind of just dismissed it and left that to the local school boards. I don't know if you remember reading that, but it made me think of that when you were talking about cheerleading.
I think
because it's very, to me,
she had something in. They looked in her purse, and she had something. She had a hydrocodone in her purse.
That's what it was.
Yeah.
I remember reading that, and it made me think of that when you talked about cheerleading, because for it not to be recognized as a sport until 2015, and there have been fights, especially you being a cheerleader. I was a cheerleader in high school, and you know how petty it can be sometimes when people don't get in that feel that they should get in, and all the arguments that happen over that.
I think the Stokes versus Ennis ISD was also a cheerleading case where she didn't make the team because the judges were, biased or whatever. So there are there are cases and cases and cases and cases on cheerleading, which is very, very interesting that it didn't become a UIL sport until 2015. I don't know.
Oh, that's interesting.
Okay, a lot of kids are, say a kid moves from yours to another school and their family builds a house there and they're a resident in that other town. If their past school signs a participation waiver, then that will allow them to go to the other school. But when you're talking about the Hardy versus UIL with the Early and San Saba case, the kid moved from Early to San Saba and they played each other. And so Early was like, we're not signing off for you to play against us to beat us. And we kind of go through that here quite often. But the way we see it is we sign off on participation waivers for our kids to play at your school in hopes that you'll owe us one whenever a kid moves from your school to our school.
Yeah.
Dallas ISD went through a lot of controversy with students moving out of district. Basketball, they lost a lot of championships. I believe it was South Oak Cliff in Dallas. They lost championships due to moving students around, because of talent. And which that also broke UIL rules as well. There's another case, Morris versus Escobedo, where Morris alleges that when she assessed the athletic program at Skyline, she noticed a lot of violations, UIL violations, including theft of tens of thousands of dollars in the track program, coaches who were paid to coach 2 sports but only coach 1, the retention by some coaches of non-DISD personnel to coach Skyline students, and also coaches referring to students in vulgar or racist manner, and coaches changing students' grade to avoid the no pass, no play. So during that time, you had, let's say you have a student that's, he's this awesome player on whatever team, but then, you go look at all his classes, and he's probably failing maybe he's failing one or two classes. Well, coaches would go talk to the teachers or whatever, and of course try to get the teachers to change their grades. So I know those types of controversies also went on in Dallas, and I'm sure that's probably one of the ones that they were talking about there.
Okay, well, the case that I researched was the Spring Branch ISD versus Stamos, and it was a direct appeal brought by the Attorney General representing the Texas Education Agency and others. They were seeking immediate appellate review of an order of the trial court which held unconstitutional and enjoined enforcement of a provision of the Texas Education Code, the no pass, no play rule. In this case, the court's sole responsibility was the constitutionality of the no pass, no play. District court had ruled that it was unconstitutional on the grounds that it violated equal protection and due process. Stamos challenged the constitutionality of no pass, no play rule on the grounds that it violated the equal protection clause of the Texas Constitution. He argued that the rule discriminates against students with learning disabilities and was subject to strict scrutiny under equal protection analysis because it infringed upon a fundamental right, which was the right to participate in extracurricular activities. For this part, the courts struck it down based on the standards set forth in a case, Sullivan versus UIL. There was tons of other cases cited as well. Regarding the due process argument, the courts made it clear that the federal Constitution's due process guarantee does not protect students' interest in participating in extracurricular activities. So then they went to check or look in the state law. According to the Board of Regents versus Smith, nothing in either our state constitution or statutes entitle students to an absolute right to participate in extracurricular activities. So therefore, the court reversed the district court's judgment with regard to the constitutionality of Section 21.920 of the Texas Education Code and dissolved the temporary injunction ordered by the district court. So there was tons of cases having to do with the students with learning disabilities and for the due process.
Did you mention Goss versus Lopez?
No, I did not, but I saw it.
I think that's one of the first ones where why a school can't kick a kid out of school because education is considered property and a fundamental right, but extracurricular activities is a privilege. So I think it all dates back to the Goss v. Lopez case where education can't be taken away without due process, but a extracurricular activity can.
What I'm going to start off with, and it kind of contradicts what you're saying, I did research from a sports law journal, the Marquette Sports Law Journal, and it was Volume 2, in case anybody wants to look it up, Volume 2, Edition 103, and it said that in the beginning that the first public school, that their purpose was just to get students to read, and that schools nowadays are really based on academic achievement, right? That that school reformers thought that the way to increase academic achievement was to have extracurricular activities. Now we're fast forwarding. They're saying that the reformers now are saying that they feel like a lot of the extracurricular activities are having a negative effect, that students, they're not having as high of an academic achievement rate that they thought they would have by adding all those extracurricular activities. And the people who challenge that, they challenge it on the fact that people who say it's not fair to have those requirements, they say it's infringing on their fundamental rights, and that there's something else that they call suspect classification. Now, the U.S. Constitution, as we've read in this class, is that it said that education is not a fundamental right. So they're saying that because of that, and that the United States Constitution does not guarantee a free public education, that they're saying that the state courts have concluded that the right to participate in those activities does not rise to that level of being a fundamental right. So that's where I'm kind of, I don't know now, like, if this is based on a sports law journal, and I thought, well, you know, that's kind of contradicting what we're saying. But I know that we're protected under that all our school comes from the Texas legislature, right? They're the ones that set the standard for that. But another part, and I'm going to move on, is that the 14th Amendment prohibits like statutory classification schemes, and those classification schemes, if y'all remember, are like you can't discriminate upon sex, race, allegiance, or national origin. And I know that, and I don't know your last name, Raina discussed the Stamos case. There was a case, and none of you have mentioned it, so I'm kind of glad to have something to talk about, is that Bell versus Lone Oak Independent School District. They had a case where students, there was students who were married, and they wanted to participate in extracurricular activities, and their school district did not want to allow them to participate. And when it went to court, the court held that it's illogical for a school district to make a rule punishing a student for entering into a status that is authorized, which is marriage, and it's sanctioned by the laws of that state. So if students are married in high school, I don't know, unless, I guess, with parent permission, that you can't keep them from participating in extracurricular activities. I thought that was interesting.
It's funny that you mentioned that, because I remember my grandfather telling me a story, because he got married his junior or senior year, and his high school didn't allow him to play football his senior year because he was married. And I always kind of thought, is that one of those old wise tales that you tell grandpa? Is that truth? And now I think, wow.
Well, you know, it's funny to me that you don't think about, you know, I don't know, because we don't think about things like that. And then being in this law class, you realize, oh my gosh, there's practically a case for anything you can think of. I would have never thought about, you know, that somebody's going to sue over the fact that they can't play just because they're married. Mm-hmm. You know, but of course it makes sense when you read it in their words, when it says marriage is recognized. You know, that's a state law. It's a recognition of that bond, you know, of that commitment or that bond that people make. And why would, you know, how could you stop? And that would be like discrimination, that you can't play just because you're married. I do else want to, something else I want to say is kind of piggybacking on what Raina said about the due process, substantive due process and procedural due process. We just kind of read about that substantive process has to do with, let me think, the attributes of ownership of property, okay, and that procedural is when you feel like you have to be heard, you have to have the chance to speak your side of the story. And they were saying that concerning eligibility requirements, that more than likely that substantive due process, the challenge to academic eligibility rules, will be defeated because the courts have refused to recognize that as a fundamental right, and that procedural due process will also be defeated because a student's interest in participating in those activities is not a protected liberty or a property interest. I don't know if y'all remember reading that here recently. This says that the courts are going to generally have ruled that the right to participate in extracurricular activities is not a fundamental right, nor are those who participate in that part of any kind of suspect group.
Awesome blossom. Okay, I think we have exceeded our 30 minutes. Everyone, please don't forget to do your peer evaluations. And if no one else has anything to say, we will stop the broadcast. Or forever hold your peace.
Yes, good.
Thank
All
you.
right. Mm-hmm.